Good evening and welcome to yet another edition of Law and Order, brought to you exclusively by Channel I. Tonight we continue with the question of inheritance. Last week we talked about intestate succession, and that is when an individual dies without leaving a last will. Tonight we are going to talk about the entire gamut of law relating to last wills. And once again, to take on this challenging topic, we have none other than Ms. Soumya Amarasekara. Thank you, madam, once again for being with us. It is a real pleasure to have you on the show.
Thank you, Mokshini. Pleasure is all mine.
It was really great to discuss the entire area of intestate succession last week, and how an individual becomes entitled to property when someone dies without leaving a last will. But tonight we will talk about the entire question of a last will. So I know we touched upon this last week as well, madam, but for the benefit of our viewers, could you just recap on what a last will is and what the requisites of a legally enforceable last will are?
Okay. Now, a last will is a document which is left by a person and executed before his death, leaving instructions as to how his assets should be distributed after that person's death. So, normally there are basically two ways in which you execute a last will. A person can make the last will by himself and execute it in the presence of 5 witnesses. That is called a 5-witness will. Then you get the other type of will where you execute the will in the presence of a notary and 2 witnesses. But the rule of the thumb must be all those persons must be present at the time of the person making the last will signs the document, and they all must sign together in the presence of the person who made the last will. All the parties involved in making this last will must be present together.
So, if we take the first type of last will where it is attested by or witnessed by 5 witnesses, the person who is writing the last will has to sign in the presence of the 5 witnesses and vice versa.
Yes, that person need not necessarily write it, but the instructions will be left in a document, but that person must sign it in the presence of the 5 witnesses, or to say the very least the 5 witnesses must be aware that person is putting that person's signature to the last will. They do not need to know the contents of the will, but they must know that that person is signing the last will, and they must see the person signing.
Are there any restrictions on the type of individual who can sign as a witness to these wills?
No, there are no restrictions, but normally if you have signed as a witness to a last will, if you are named as a beneficiary, you can't get the benefit.
Oh, I see.
Yeah, the will be valid, but you will not be able to get the benefit that is left you under the last will.
I see, okay. And if it is the second type of last will, it is the same. The notary has to be present to witness the executant signing the will.
Yes, so normally the second type of will would most probably be prepared by the notary himself, but it is not necessary. But what is important is that that person must sign the will in the presence of a notary, and that has to be witnessed by 2 other individuals.
Madam, there are instances where a last will, or say someone has just written down how he wants his or her property distributed once he or she dies. In such instances, now that is before, and he dies before it is executed in one of those 2 ways. Is it, does that still come under the category of a last will, or it's intestate succession?
Yeah, it is intestate succession. Unfortunately, that has no binding effect.
There's no binding effect, right, okay. And I don't know whether stamp duty is necessary, because it's a document which deals with immovable property. So is that a necessity for stamp duty to be paid?
That I am not 100% sure. You'll have to check that with a notary.
Notary, right. Thank you, ma'am. Now, once a person dies leaving a last will, and the last will is discovered, or it has been left with a notary, or one of the beneficiary discovers the last will, what steps should they next take?
Now this happens in several ways. There is a provision which says if any person discovers a last will of a particular person, that person has the responsibility of depositing that to court. So,
the last will.
The last will to court. So, normally you would normally the last will would be brought to court by an executor named in the last will. Just to explain that slightly, very often when a person makes especially a last will in the presence of a notary and two witnesses, some legal advice would have been given most probably. You name a person as the executor. That is, you name a person who has to look after the estates and carry out the wishes of the deceased. So, that person is called the executor, and very often you name that person. It can be one, it can be several, but you name a person.
In the last will, that person's name is specifically mentioned.
Then such person would normally bring the last will to court.
Okay.
And produce it before court, saying that this person has died, leaving this last will, my name has been given as the executor. So, please first accept this will as the valid will and then appoint me as the executor. So, that is how it would normally happen. But there are some instances where you either do not name the the executor, or the executor you have named does not want to act as the executor, or the executor is not in Sri Lanka. So, then what happens is a person who gets the benefit under the last will might bring the will to court, deposit it in court and ask that what is called letters of administration, as opposed to, these are very technical things, be given to that particular person to administer the estate. So, sometimes if the executor named in the last will is living abroad, he can get his power of attorney holder to come to court and ask for letters to act. Otherwise, an heir can come and say there is no executor named in the last will and proceed. But anyway, whoever who finds a last will has an obligation to deposit the last will in court.
So, deposit in court means they have to initiate action?
Initiate action means that person's responsibility would be to come to court with the last will, file a petition which is supported by an affidavit and say, I have found the last will of this person, and as far as I am aware, this person has these assets, and I am depositing this document in court for necessary action. But generally, almost every case that I have come across, it is always a person who has an interest in the estate who will take the trouble to come to court and deposit the will and proceed from there.
So, what would be the steps that follow once you initiate action and the will is deposited in court? Do all the heirs who have been named in the last will have to also be made parties to the action?
No. In the case of last will, it is, if there is executor that is named in the last will, you would name the executor would file a petition.
Yes.
And in the body of the petition you would name all the heirs, that is the intestate heirs, those are the heirs who would get if the person had died without a will, as well as the persons who would inherit from the last will. Normally, you can include that in the body. I have seen cases where people make them respondents, but it is not necessary.
Madam,
and when you come to court with a last will, you will also file affidavits along with your petition from the notary and the two witnesses, saying that they were parties to this will and they were aware of this being executed.
So, along with the petition which has been supported by the affidavit of the executor or whoever is coming to court, other affidavits of the notary and the witnesses also have to be filed?
Yes, normally they are always filed, and you also file a death certificate and you also file the last will.
And in which court testamentary actions are usually filed in which court, and what jurisdiction applies then in such instances?
There are three places where you can file. First would be where the person was residing at the time of his death. The second one is where some of his properties are situated.
Oh, I see. Some, any?
It could be any, there is no specification. The law requires the property, there has to be a property within the limits of
the territorial jurisdiction
of a particular court. And the third one is where the executor is residing.
So, any one of those three?
Any one of those.
So, for example, if the property is situated in Matara, but the deceased died in Colombo and the executor lives in, say, Gampaha, any one of those three places?
You could go to any convenient forum.
In the district court?
Yes, it's in the district court.
Okay, ma'am. So, once a case has been filed like this and an action has been instituted for the administration of this last will, the property of the deceased, is there any provision in the law for someone to object to the deceased property being distributed according to the last will?
Yes. In the case of a last will, or even where you die without a last will, when you institute any testamentary proceedings in a court, the court gives notice to the entire world. So, the court gives a date and these particulars are published in newspapers in 3 languages, English, Sinhala and Tamil. So, once that is done, it is noticed to the entire world that the testamentary proceedings have been instituted by some person, and there are some details of the testamentary case. So, if you have any interest, then you can look into that, and if you are objecting to it, that is the court also gives a date on or before which you have to file objections. So, then you have to come to court and file your objections.
So, if for example, I am a creditor and I find that this person has died, I have a right to file objections, do I?
Actually, I don't think you need to file at that stage, because the first stage is to announce that there is a last will or that a person died intestate and that there is a particular way of distributing the assets.
Right.
So, supposing you are a creditor, you will actually not object to the last will being proved. First stage is to decide as to whether there was a will or not.
Right.
So, there is no purpose in you objecting at that stage, because you do not mind, somebody has to be appointed either as an administrator or as an executor of the estate. So, sometimes like if you are a creditor, you will not object to it at that stage, but once the court decides whether there is a last will and as to who the heirs are, and when the inventory is filed, I told you earlier on a previous day also that a inventory has to be filed. At the stage of filing the inventory, you set out the assets and the liabilities. Then you check to see what the assets are, what the liabilities are.
And whether you have been named.
Whether your debt has been shown, then you can come in. Of course, there are other instances where say the deceased person has disposed of the property before his death, but it is included in the inventory as an asset belonging to the estate. Then I have seen people coming and objecting at that stage.
The actual owners.
Actual owners saying this can't be part of the dead man's estate because he has already disposed. So, the objections are really meant in the first instance to the granting of probate or accepting a last will. So, at that stage there are people who will say this will is a forgery. You can say this person who at this time of signing did not know what that person was signing, or you can say even though you have produced this will, there is another will done thereafter. So, that first stage is to decide whether this deceased person actually left a last will or not.
That brings me to my next question, madam. Now, if there are multiple last wills that have been left by a deceased person, I mean, an individual might change his mind about who he wants the property given to. What happens then? Which last will actually will be considered as the
it's the last one.
The last.
It's the last one.
And
another thing I must just mention is, if a person makes a last will and thereafter get married, then that last will goes out.
It's no longer
valid.
Right. So, if he has executed a last will before he gets married, that no longer has any effect. Right. Ma'am, now once a case has been filed, the executor is required to prove the last will.
Yes.
So, how does one actually satisfy court that this is an authentic last will?
So, you have to produce the original to court. Normally, when you come to court, you will produce the original before court, and then you give affidavits from the notary and the 2 witnesses. So, if there are no objections, that is sufficient, because they are swearing to the fact that there was a last will. Of course, there is if there is a challenge, then you have to call the witnesses definitely to say that this man executed the last will in our presence.
So, they have to come and give verbal testimony that
Yes.
they were present and so on and so forth.
So, these are highly technical things. So, and these are very contentious matters sometimes.
Yes.
And sometimes if there is an allegation of fraud, it is also safe to call the notary. So, but generally one of the 2 witnesses must give evidence.
And if there are situations where someone is aware that there is a last will, but cannot locate the original, what other options do they have?
So, there are times when people come with copies. Normally, a last will is executed in 2 copies. So, one is with the notary, one can be with the deceased. But the thing is, with regard to last will, if the will cannot be found, there is a presumption that the person who did the last will destroyed it.
Disposed of it, okay.
Yes. So, you can, once you make a will, you can dispose of the will by destroying it or writing another document which is notarially attested, saying that this document is no longer valid.
Right.
So, in so many ways that can be erased. So, basically if the will is not forthcoming, the presumption is that the deceased destroyed it.
Right. And is there a time period within which someone should come to court?
Yes, 3 months.
3 months once again. Now, again ma'am, if the will only talks about certain assets which belong to the deceased, but an enthusiastic and duty conscious executor does his homework and discovers that the deceased actually left much more property than has been specified in the will, last will, what should the executor do in such instances?
So, very often you will find if a will has been executed by a notary, there is what is called at the end a rest and residue clause. That is, there is a clause which says whatever I have not specifically mentioned here is to go to a particular person.
Right.
But if that is not mentioned, then that part will be distributed on the basis he died without a last will, as far as those properties are concerned.
Oh, I see. Okay. So far as those properties are concerned. So, then intestate succession comes into play, is it?
Then intestate succession
I see.
comes.
So, whatever properties has not been specified in the last will, if there is no rest and residue clause in the last will, gets distributed amongst his heirs according to intestate succession. Right. Ma'am, now during, for example, if it is a contentious testamentary case and there are objections filed, what kind of time period would a case like this take? I know it's a difficult question, but
it can take any time from 3 years to 20 years, 30 years. You can go up in appeal. So, it is a long process. Nobody can give a time frame.
But it is absolutely essential for an action to be filed, because otherwise the last will would be taken as not being proven in court, isn't it?
That is the thing. In order for you to get any rights under the last will has to be proved in court. Unlike when you die intestate, even if you do not come to court, you get rights. It might take some time for those rights to be legally recognized, but they will be recognized. But if you are claiming under a last will, you do not get any rights until you go to court and prove that there was a last will.
Madam, in a situation where the executor, I know you touched upon this earlier, but the individual who has been named as an executor in the last will does not want to discharge that duty, does not want to be burdened with such a duty, what can he or she just refuse?
Yes, they can. They can.
And then it would be the heirs.
Then one of the heirs or some other suitable person will apply to court to be appointed as the, that's called the administrator. Executor, these are very technical
Yes.
things. Executor is a person who has been specifically named in the will.
Yes.
Anybody else that deals with the property is called the administrator.
Administrator, right. Now there are also instances where the last will is, those who are objecting state that it is a forged document.
Yes.
So if they are, if that is the objection that they are taking, if that is their stance, then the person who is relying on the last will, how do they actually prove that this was the signature of the deceased, and so as to satisfy court that this was actually something that was signed by the deceased and not a forgery?
Yes. Now, something as serious as a forgery, the person objecting, I would say, must take it up as the first instance. So then when you call the witnesses to the last will, they are saying, no, this is not a forgery, this person signed in our presence. Then if you want to be, if you want further insurance, you can send the document to the examiner of question documents.
Examiner of questionable documents.
And ask for verification, but that is not absolutely necessary. Normally the requirement is the witnesses can attest to the fact that this person signed. If you want, if you like, in a case like that, it's also safe to call the notary.
Call the notary. There are also situations where the notary also has died.
Yes.
In those instances, then you just, there's nothing more you can do, isn't it?
There is nothing more you can do. Of course, you can, if necessary, call people who are familiar with the signature of the deceased to lead. But the question is whether that person put the signature to that particular document. So even though the signature might be yours, it is better to call the EQD if possible.
Madam, now while a testamentary action is pending, can one of the properties which is in that, which is included in the last will, can it be disposed of while the action is going on?
No, it's like when I mentioned earlier, like when you die intestate, you shouldn't dispose of the properties till the letters of administration is granted. So same thing goes
Where, for a last will.
For the last will.
So
Till
once.
probate is issued, you can't deal with the property.
And by probate you mean empowering the,
Till the will is proved and somebody is appointed to look after the affairs of the estate. Till then you can't. Especially in the case of a last will, you can't deal with it till the last will is proved, because till the will is proved, you don't get
any rights.
any rights.
Well, I think that really covers everything. I think we have not left a single stone unturned, Madam. Thank you so much. I know I grilled you quite a bit. I'm most grateful for you taking time off your busy schedule to share your expertise which you have gathered over the last 30 years that you've been in active practice. Thank you so much, ma'am.
Thank you, Lakshmi.
That brings us to the close of this week's edition of Law and Order. Thank you so much for joining us, viewers. I'm sure that you enjoyed this week's show as well. Join us again next week for yet another edition of Law and Order. Good night.